Okay, once we're there, hopefully we are live. Thank goodness. We're going to go and so this recording we're going to be talking about causation in contract law. Now, you guys are probably aware that I use the analogy when we talk about damages in tort, damages in contract, and how in contract they're generally more powerful because we care about the bargain. We care about the loss of a person, and again, that rule and principle in Robinson and Harmon, to put them in the position that they would have been in if the other side did what they said they were going to. So the three components to this is really to do with kind of ways of limiting damages. And you will see this sometimes where you'll actually have people saying or referring to this as being limits to damages. You might see that as your in your textbooks. In some of your textbooks it will go through and have that, because the three things that we're going to be looking at is causation, which is really the mechanism that we use to link a packet of harm back to a breach of contract. That's the first bit. We're also going to be looking at the test for remoteness, which is basically trying to determine how far a particular piece of harm is removed from the breach itself. If it's too far, then you can't see compensation. And then the third bit's going to be looking at mitigation, as the common law rules for having damage awards reduced through the plaintiff's inability to somehow take some reasonable steps to do things. So we're going to start off with causation. And we're going to be looking at this causation, which is in many ways is similar to what it is in tort. So for those that have had the benefit of going through and doing tort, you will find that some components of this are going to look kind of similar. And really the key takeaway in contract law is that it's just a simpler test. Now, very unfortunately, when we're looking at tests that are simpler, that can sometimes be a little bit more problematic in itself. But I can say, hand on heart, when you are going through and you're looking at things in practice, in contract law, these rules for causation, they're important. And they're important because you need to be able to prove this thing in order to get some dollar awards. Okay, let's flip it over here. All right, so the starting point is, in contract law, you only get dollars, substantive dollars, if you as the plaintiff prove that your loss was somehow caused by the breach itself. So one side has a breach of contract, and you as the innocent party, we know so far that any breach of contract is going to give you damages, but if you can't prove that there was some form of loss, you only get nominal damages. Here's $10, here's $20, here's $100, go away. And it's important to note that, yes, you always do get dollars, but the amount you get is going to change a lot. And last week we looked at the principle of Robinson and Harmon, that whole idea of damages is supposed to put you back to where you would have been if the other side did what they said they were going to do. And that's true, but you've got to prove that. And you've got to prove all of the different packets of harm. And this is one thing I feel is underdone when we teach you guys contract, and particularly when we teach you torts. Now, I'm not teaching you torts, I'm teaching you contract, and the tests are a little bit simpler. But you need to know that when we think of a breach of contract, a single breach can actually cause a variety of packets of harm, a variety of situations or scenarios that are going to require you to be compensated. All right, there's going to be a variety of packets of things that flow from this. And again, and this is similar, analogous to damages in tort. Somebody has a duty of care and they fall below the standard appropriate for that breach, and falling below that standard causes some form of harm. You have to prove each of the blobs, each of the little packets of harm flowed from that particular breach. Okay? And this is often the killer in actual real-world contractual disputes, because sometimes it can be very easy. In the Chute question, for example, the breach caused loss that was very easy to prove because the amount was written in the contract. But it can be a lot harder when there are lots of factors in play. If there are lots of factual situations that intersect with all of the particular bits of harm that have come to you as the plaintiff as a result of breach. And so you've got to appreciate that this causation test, both in contract and in tort, these are questions of law. And very unfortunately, in contract, the waters have been somewhat muddied. So I'll start with, I'll start with the simplest of tests. This is the simplest of tests. This comes from March and Stramaray. This is a torts case, and you'll notice the year on that. I do talk at length, sometimes with a big smile on my face, sometimes shaking my head, that the makeup of the High Court of Australia has a really strong bearing on some of the decisions that came out of it. In particular, some of the more progressive or controversial decisions, many of those came about in the reign, the period of what we call the Masen Court. So Sir Anthony Mason, when he was Chief Justice. For those that have studied some other areas of law, again, administrative law and trust, the other things I'm teaching, you'll find that there are judgments where Justice Mason, as he then was in the early 80s, was very thoughtful. And he would have judgments on his own. And in the time of Sir Garfield Barwick and Chief Justice Gibbs, these are very, very conservative High Court judges, and they were very conservative, almost libertarian courts themselves. And so it got to be very progressive by the time Sir Anthony Mason became the Chief Justice in 1987 or 88. And so there are some famous cases, Rogers and Whittaker, all of the Section 92 cases. Marbo was a decision on that period. And so this one, March and Stramaray, which was to do with negligence. And really they had to go through and look at the liability that people would have. There was a truck driver that parked in the middle of the road, and a drunk driver crashed into him. Was the truck driver liable? The Mason Court said yes. But the particular facts of that aren't too important for us. What is important is that this test, they talked about it, and they said, look, this is really the starting point. The starting point for determining causation at law in Australia is the but-for test. It sounds very simple. Would harm have come to the plaintiff but for the breach? If I flip that around, plaintiff needs to prove if there was no breach, she or he would not have suffered the harm. It's deceptively simple in me explaining that, and certainly Reglass and Rivers locking system is a contract law case. It involved, as you could probably imagine, a locking system where there was a contract to put a system of locks into a building, and one might argue if you put a system of locks into a building that there's probably an implied term that those locks would keep burglars out. And they didn't. Didn't keep the burglars out. Burglars came in. And this went all the way to the High Court. And the High Court looked at this and said, well, if you had did what you had promised to do, put in a locking system that worked to keep burglars out, the burglars would still be sitting outside, angry, with their baseball bats or whatever else they were carrying, or crowbars at the time. And so that this test is very simple. It's a very, very simple test. But like anything in life that is simple, the devil is in the details. And so when we're going and trying to use this test in simple scenarios, like Reg Glass and Rivers locking system, it can work quite satisfactory. Hey, if your locks had worked, the burglars wouldn't have come in. And that's fine. What you find, though, is that a variety of other factors come into play here. Did the burglars bash the door down? Did the burglars climb in through a window? Did the burglars do a variety of other things in regards to this? Were goods left in the shop window in order to encourage the burglars to come in? All of these factors, while none of them are determinative, can cast some sort of doubt about this factual connection between doing or performing a particular function and a particular result happening, and not performing that function and a result not happening, because all instances of causation and using the but-for test are hypothetical. They are essentially philosophical questions. What might have happened? And that's why that causation seems simple, and it seems simple to lay people, and I cannot stress enough for you guys pushing towards becoming lawyers how fraught with difficulty the tests of causation can be. They're a quasi-mix of law and fact, and they all involve some form of hypothetical situations and often value judgments from the bench. They are difficult things to do. And ironically, the contract law test is arguably much simpler than in tort. We have a simpler test for causation, and again, later in this lecture, we'll talk about the test for remoteness, which is arguably much more complex. But this is the starting point for contract law. This is where a plaintiff must prove some form of hypothetical situation, a balance of probabilities, that if the other side did what they said they were going to do, you wouldn't have suffered that loss. Now, this test in contract is really tempered by what I call, and what some other call common sense. And again, that is a term fraught with danger. And this case of Alexander and Cambridge Credit is a situation where the courts had to temper this but-for test with something of a very large dash of common sense. And common sense is never what you want to have as a source of law. It is fraught with difficulty, as I'll explain with this case. So Alexander and Cambridge Credit involved a firm of traders. I'm not sure what the specific industry they were in, but they got audited. They got audited in the 70s, late 70s. And the auditors were negligent. Okay. Now, when I say they were negligent, if you pay somebody to audit your books and they make a mistake, they fell below the standard of a reasonable care, of a reasonable professional in that case, and they didn't notice a whole bunch of errors and mistakes in the books, right? That's going to be a breach in terms of tort. Because it was a contract, it's a breach in contract as well. Okay, and we know in terms of this difference between tort and contract, again, with the law as it applied at the time, that if the amount is much larger in contract law, you go for the contract remedy if you can. Tort will put you back to where you were, contract puts you where you would have been. Now the difficulty was here that there was a loss. They had basically, Cambridge Credit carried on trading, and after a year or two they'd lost something like $11 million. Quite a large sum of money. Okay, now they carried on trading the negligence of the auditors wasn't discovered after a period of time. They carried on trading for another, I believe it was 4 years. And because of all of these errors in the books, that loss compounded something absurd to something crazy like $120 million. Now, a couple of other things that happened though at the time. This was a lending unit and they were operating in a very difficult time in the mid to late 70s. The audit might have been the mid 70s. It was late. There was a credit squeeze on in Australia anyway, and the losses compounded something massively as a result. No, my stream's gone offline. Okay, let's come back. So the court, and this was Justice McHugh, by the way, this is before he made it to the High Court. And there he said that, look, if you were just using a bog standard but-for test without any accommodation for any other factors, sure, you could make an argument that the auditor be held responsible for $120 million worth of loss because they made a mistake. But a couple of other things have happened here. One is the intervening event of the credit crunch. It's a factor. It was really not foreseen by the parties. It acted outside the scope of this particular contractual arrangement. And arguably that broke the chain of causation. We call that, again, it's on the next slide, a novus actus intervenes. I'll put it on the next slide. But you need to note, I think importantly, that this kind of nebulous term, common sense, was used by Justice McHugh, who is, in all accounts, very sensible judge, was very sensible on the High Court as well. But essentially what he's saying is that you can't, when you've got this but-for test, where things are magnified out of control of all of the parties, the but-for test just fails. It fails in terms of contract, and arguably it doesn't in tort as well. But there's a variety of other tests that I won't go into now in tort that they use in situations where the but-for test fails. In contract, though, they said that, look, just as a matter of fact, this is a factual, essentially, factual investigation that the judge is making. That this but-for test, this very simple test, has to be viewed in light of some form of community expectation, or what we call a sanity check. I'm not sure if you guys have heard of the term sanity check. We need to go back and look at the numbers and determine whether A actually led to B. Because causation is fundamentally a philosophical concept, but the real world is complex. And this but-for test, contract law, has to be tempered by some aspect of common sense. And that term is very nebulous. It's not well defined. And a lot of judicial commentary suggests that it's bad law. Steve Raw describes it as a large packet of worms, a tin of worms that's opened up to the world. So that's really kind of it in terms of the test of causation at common law. Now, again, for those students very fortunate enough to do torts, which is, in fact, all of you, at some stage, you'll probably spend 2 hours talking about tests of causation with Luke. I'm not particularly concerned about going into this one, because in contract law, it's not actually as important. What you're going to find is the courts are pretty straight-laced about determining whether the breach of contract caused the loss. And the reason for that is actually to do with something I'll do in a subsequent recording. I'll try to switch this one over, because the test for remoteness is a little bit more robust. The test of causation in contract law is simpler. The test for remoteness is more complex. But I do just want to note this rule here, this novus actus intervenes. Again, this is also a tort contract as well. And there, I'll talk about Lexmead, which was it's a UK case, but it illustrates the point quite well. In that, if there is some supervening event that comes in and interferes in some way substantially between the breach of contract and the loss being caused, this will break the chain of causation. Call that an intervening event, or in law, because we love Latin so much, novus actus intervenes. And so Lexmead involved a tow rope. I know, it seems pretty crazy to go to the House of Lords for a tow rope, but nonetheless it did, because... Jordan. Sorry? Well, when you talk about at that point before the chain, in other words, when you break the chain of causation, yes. If you can calculate, the question of the recording is, can you get damages up to the point where the chain is broken? Yes, but the point earlier that I made about proving packets of harm, so for each given packet, for getting from A, where the breach occurs, to B, where this packet of harm you're trying to claim is, you won't be able to get B if you've broken the chain of causation. If the breach leads to other forms of harm, in other words, coming up towards the point where the intervening event occurred, sure. But that is essentially analysed as a separate packet of loss, usually. And often what you'll do, again, this is analysed in terms of remoteness, where you've got a loss, and say for, again, I'll save it for the later recording, but it's in a situation where something obvious happens in the breach. You run into somebody, you cause the loss because I've breached the contract. In fact, Lexmead, for example, involved a tow rope. Right, got a tow rope. Negligent, they didn't make it very well, it broke. The trailer careened off, hit somebody. Okay, if you think, well, the breach was the poor quality tow rope, and we could say, oh, well, we can argue that would the harm have come but for the breach of the tow rope? Well, probably not. So we can probably succeed on that one. But then if that person, for example, happened to be a carer for another person, they had no other person to care, or if they had a very specific job at one particular organisation, and that organisation then went bankrupt as a result, and then in that organisation that goes bankrupt, that goes into liquidation, all of the employees get laid off, and one of them gets depressed. And because they get depressed, they start drinking too much. And because they start drinking too much, the kids go out of control. And when the kids go out of control, you can see where this is going. This is really to do with the test of remoteness. And so that for each of those steps or those stages, you've got to analyse each of the packets of harm. And so the test for causation is to connect the breach to a particular packet. And it's okay to have a series of steps in order to reach that particular result, but appreciate the length of steps. It's much easier for the defendant to come along and say this particular event in the middle happened. So, for example, in Lexmead was a tow rope, and yes, it did break. The intervening event there, though, was the fact that the plaintiff knew the tow rope was defective and used it anyway, just sort of looped it around an extra half a loop or something similar. And so they said that was going to act as a novus actus and was going to break the chain of causation there. Really, that's what it is. So I'll finish up with this particular recording. I'll switch it over. We'll take 5. There's 3 recordings here, so we'll go through, end this one now, switch the camera, and we'll talk about the next part, which is to do with remoteness, which is a little bit longer. Okay. Thanks, team.